If you think about it, a large part of personal finance is planning to ensure that your dependents are well taken care of during and after your time on earth. And that is true whether you're leaving a modest home and a stock portfolio or a legacy that's worth crores. And yet, most people find it difficult to talk to their loved ones about money, about their investments, and even about what they plan to do with their assets. There's something about contemplating it that makes the human mind shy away, and that's understandable. But on today's episode, I want to talk about why you should face it head on. And part of that will require me to talk to my guests about what happens when the groundwork is not laid. This is Moneywise on NDTV Profit, and I'm Alex Mathew. Joining me today is Shaishavi Kadakia, who's partner at Cryll, Amarchand, Mangaldas, and Abhishek Kumar, who's founder and SEBI RIA of SahajMoney. Thank you so much for taking the time today, and it's an important conversation. Normally I start with a joke or something light, but this is not one of those episodes. Indeed. I want to talk about first the problems that people face and the crores of money that is lying in the investor education fund. It's lying unclaimed with banks. Yes. And that's because people are unaware of the assets that were left behind by their loved ones. Do you have any figures that can put all of this into context?
It would be, Alex, they run into hundreds and thousands of crores, unfortunately. The last number I remember reading is 80,000 crores, which is absolutely massive.
And also, we'll bring Abhishek into this conversation and talk about how difficult it is to pull money from that investor education fund, though it's actually possible to do. Right. Ultimately, we're talking about a situation where there is no will and there is no nomination.
Yes.
What happens then? Yes. Let's talk about the process involved. First, you have to find out who gets what, right?
Exactly. So if the question is what does the legal heir do, the question that comes before that is who is the legal heir?
Yeah.
Because in India, as we know, there is no uniform civil code. So we will have to look at the personal law of the deceased. The person could be Hindu, could be Muslim, even amongst Muslims could be Sunni or Shia, could be Christian or Parsi. So the first question is, what do we look at? For Hindus, again, the distinction is between men and women. The legal heirs for a man who passes away without a will are different from those of a woman. For instance, a Hindu man's mother is his class 1 heir, but that is not true for a Hindu woman. So it leads to all of these complications. For Shias and Sunnis, again, you will look at a whole bunch of persons who are called sharers and residuaries. And Christians and Parsis fall under a different regime. To complicate this more, it also depends on who you're married to. So if there's an interreligious marriage, a Hindu marrying a Christian, for instance, and solemnizing that marriage under the Special Marriage Act, then Hindu law ceases to apply to the Hindu person. And in fact, then the Indian Succession Act applies. So what happens is that if the Hindu man's mother would have been his legal heir had he married a Hindu, she ceases to be a legal heir if he marries a Christian. And these are the complications that most people sort of don't realize.
So you can literally write books, and I'm sure people have written books about this.
Exactly.
But then let's assume that you have identified that you are the legal heir.
Correct.
What happens then?
Then, of course, the first thing you have to do, and this is like you identified, a big problem, is in India, we don't have an asset register. We don't have a central asset register. So legal heirs don't even know what assets and liabilities the deceased left behind. Very often we have seen that documentation is not maintained properly. We also know some of the other issues in this country in terms of record keeping. So that is issue number one, which is also why a lot of these assets remain unclaimed, because heirs may not even know that those assets exist or there are liabilities that they have to pay off. So one of our recommendations always to people is, of course, you make a will, but along with that, make an asset register, because that is such an important document. And in that, identify whether there are nominees, whether there are joint holders, because in the absence of that, your family is going to have to do a fact-finding mission.
So you have to identify what the assets are. Correct. So the first step is find out that are you the legal heir? You find out. Okay, fine, that's done. Find out what the assets are. You've done that. Next, what?
Correct. Then based on what those assets are, you have to take a different process. There are multiple asset classes in India. So there could be bank accounts, demat accounts, mutual funds. There are bank lockers. There would be EPF, PPF, gratuity, life insurance, flats, societies, apartments, land. All of these. Each of these will have a different process. Again, there is no single window, there is no streamlined process. For each of these, you will have a different institution or officer to go to. So let's take bank accounts, for instance. You will go to your bank and say, there is money in this bank account. There is no nominee. There is no joint holder. Give me the money. They will look at this. And in fact, interestingly, the RBI has just in September of 2025 come up with directions on streamlining a process that they want to be in place before March 31st, 2026. And as per that, if the money is below a threshold amount, then there is a simplified process. If it's above a threshold amount, then they will ask for some sort of court document like a succession certificate or a legal heirship certificate. Similarly, for demat accounts, mutual funds, if there is no nomination, then you are likely to have to produce a succession certificate to get that. If there is a flat in a cooperative society in Bombay, for instance, in Mumbai, you would go to the society and say, look, you transfer this to us. They will ask for maybe a family arrangement, because that is what the law says now, that you produce a family arrangement. They might ask for an indemnity.
This is a document?
Yes. So in fact, some years ago, because society transmission was becoming a big problem, the Maharashtra government amended the Societies Act and said that instead of asking for probate, the society can be comforted with a document which is like a family arrangement.
Okay.
So you can produce it, family members can sign it, all of the heirs can sign it, you can produce it, the society might ask for some sort of indemnity to ensure that no one else claims it, and then they're bound to transmit it to the heirs.
So, but this is not as simple as a physical versus financial asset kind of a situation.
No, it isn't. So physical assets, of course, there's a different complication because those don't even allow nominations.
Yeah.
Financial assets do allow nominations. So if you do have nominations or a joint account, then it becomes much easier to transmit. But in the absence of those, there are hoops that everyone will have to, undergo and jump across, and which always then gets us to a point, make a will, keep your nomination.
So, and apologies for keeping you on the sidelines of this conversation, but I was absolutely curious about this entire process, and it sounds like hell on wheels, unfortunately, right? Because already you're dealing with this emotional burden of somebody passing, and then you're dealing with the stress of not knowing what the assets are, and beyond that, whether or when you will have access to it in the first place. Have you experienced these situations where you've helped families deal with this?
Yes, Alex. While Corona was the kind of a pandemic that we all faced, many families lost their family members as well. And it was that point of time, there were a lot of clients of us whose family member reached out to us, knowing that they signed up with us and their asset details were available. Like my panelist was saying that people are not even aware what kind of assets their family hold. So identifying and then telling the people who are actually the family members. So we verify their credential and then share that data with them. That these were the assets which were discussed during the kind of advisory we provided, and that helped them a lot to identify those assets. We also told them how to approach different regulators with the kind of information that would be required to create an asset register.
I'm talking about the average Indian.
Okay.
Where would they go to for this kind of information to say, does my mother have land, or does she have real estate, or does she have gold, does she have mutual fund units, does she have shares, does she have a fixed deposit?
Sure. So to segregate that part into, let's say, two parts. One is identifying the physical assets for that, but of course, unless someone was already aware of that, it's difficult to find. So you might need to, let's say, involve some detective kind of work, would find all those things for you. Then there are aspects related to financial assets. So like approaching banks or through regulators, and identifying those assets become a possibility. Likewise, when you go to a SEBI regulated assets, you can identify those assets, and then using legal heir certificate and succession certificate, you can identify and pass on those assets to you. So that is the process that we suggest when people reach out to us.
So you would ideally go to. So by the way, I covered this when it was announced, but the DigiLocker now allows you to have a nominee where you can share financial details with for your shares as well as your mutual fund units, which is a great deal, right? So the most important thing, and what I'm getting from what both of you all are saying, is that it's important, first of all, to know who the legal heirs are, and the second thing, you need to know what the assets are, after which you can talk about distribution. Let's talk about ideal process now. right? How watertight or airtight, as the case may be, is a will?
Yeah.
Because I keep hearing the fact that, okay, sure, you can make a will, but it can be contested.
Correct.
And it can take years for it to be going through.
That's absolutely correct. And we say years, we actually mean decades, to be honest. This is a question that I get asked all the time when I'm making a will for a client, is how do I stop this from being challenged? I think it's important to understand who is going to challenge it. Only a person who's aggrieved by what you have written in the will. So the first thing when a person makes a will is to think about, am I doing someone an injustice, or is someone going to perceive that an injustice is being done to them by the will I have made? If that is the case, why are they going to feel that? What have I done? Have I not given them an asset that they believe they should have? So that is very important to understand. Who is going to challenge? The second thing to understand is on what grounds are they likely to challenge? Because there is again some misconception about how you can challenge a will. So when can a will be challenged? If the person alleges that the person who's making the will did not have mental capacity to do it, old, aged, in the hospital, or if they have made a will which is so one-sided or benefiting only some members of the family that it could be argued that there was some influence on them, or they were under duress, or there was some fraud played on them, or there is some kind of forgery of the will. So all of these, if there are any suspicious circumstances that will may suffer from, then it's important that we identify those and then solve for them. So when we're making a will, the first thing to make it watertight, of course, is to make it unambiguous. If the bequest says that I have jewelry and I'm giving it to my children and they can decide what they want, that is not a bequest. That is an ambiguous bequest. So we want to avoid those.
So you be very clear. It's
very clear.
This particular grammage or these particular stones in set, and you make it as clear as possible.
You make it as clear as possible. If you're giving a bequest to one person, if you're saying my wife and after her my son, do you mean that your wife only has life interest, so she stays in that flat only for her lifetime? Or actually, are you giving her the flat and saying, if she is not there, then my son gets it?
Right.
So these are the small, it could be a matter of a few words, but it still makes a difference in how the will is interpreted.
Okay.
And post that, so what you need to think about is, okay, I have made this will, someone's likely to be aggrieved. Can I write in the will why I have made a certain decision?
Sure.
If you have two daughters, for instance, a hypothetical example, one is married, one is unmarried, lives with you, and you want to give your apartment to the unmarried daughter. Explain in the will, saying I have given a lot of my property to my married daughter on her marriage. She is well-to-do. She doesn't live with me. There is this other property that I'm giving to my other daughter. Explaining those bequests goes a long way in the aggrieved person understanding what the thought process was.
I have also heard that when you do make a will, you can actually, around that same time, go and get a full body examination done and a certificate from a doctor.
Exactly. So when you're making the will, there are a few safeguards that you can put in place. You can get a medical certificate, but it should be of the same day as the will.
Sure.
Because you could be perfectly fine day one and unwell the next day.
Sure.
So get a medical certificate. You can also get your doctor to be a witness to the will, but it depends, that depends on whether the doctor is going to be accessible to your family to come attest for the will at a later date. You can also video record the signing of the will, and not just the signing, because it can be literally any document the person is signing. You would ideally want the person to read out the contents and to mention in front of the camera they know what they're doing.
Sure.
And then sign it and the witnesses sign it. So you can videotape the whole thing. You can register the will as well. You want to destroy all your earlier wills, so there is no question on what is the will that you want prevailing. Ensure that you don't have hand markups in the document. Store it properly so it cannot be tampered. So there are all of these things that you can do.
I have to ask this because it's not really fiction at this point, right? It's even with all of these safeguards, from the standpoint of a lawyer, you tell me this. Can it still be challenged?
It can still be challenged, and this is something I tell everybody. We cannot stop an heir if they feel aggrieved from going to court.
Right.
Then they of course have to prove it. That is the important thing. Anyone can go to court and say, look, I am a legal heir. I feel like this will is not valid and I am challenging it. The burden is of course on them to show the court why they're challenging it. If they have good reasons, if there are suspicious circumstances as the court says, the court will listen to them. If they don't have, if it's a frivolous sort of challenge that they're making, then the court will dismiss it. And so what we want to do is ensure that we have enough evidence to help the court come to a decision that the will is valid.
And a video would help.
A video helps. A video helps a lot. A video helps a lot. When you take the video, keep the original sort of, if it's a card that you're using, keep that. Don't tamper with it. Don't edit it. So even a small thing like editing may question saying, okay, this is edited. Has something been edited that we don't know of? Keep the whole video.
Sure. Okay. So that's from the making of the will standpoint and trying to make it as airtight or watertight as possible. But let's talk about how to have these conversations, because ultimately if your family does not know what you own, that's problem number 2. Do you advise people to have these conversations on an ongoing basis? Because we ran polls, and interestingly, I think only about 18% of the respondents were truthful when they said that they don't have these conversations and they find it uncomfortable to have these conversations.
True. So this is a difficult conversation to drive, but this is one that need to drive at any cost, because life is uncertain and you need to talk about how, let's say, distribution of your assets or responsibility would go around in your absence, right? So like when a couple comes to us, we always advise, even if say your spouse is non-working, do involve her in the discussion that you are having. So she is in the knowing that what is being discussed and how the assets are being, let's say, accrued over a period of time. So that is a good starting point. And when they have, when the client comes or a couple comes and they have adult kids, it always is beneficial. They discuss what all assets they have accrued over a period of time, and perhaps not put it that upfront to them, but transition them to get to a point where they are comfortable knowing that what all would, let's say, get passed on to. And then as Shaishavi said, that probably writing the intent also, that why they are giving equal or unequal shares to different, let's say, siblings as such, would help them in managing those kind of conflict later on. So, I mean, as someone said, right, sunlight is the best disinfectant. So keep it up front, don't hide, and have that frank conversation is always what we advise, and that helps a lot down the line.
I would think that the most watertight situation would be if the entire family is in the video.
The entire family, so that's one option. The other one is we say draft a family arrangement at the outset. So get your family together, tell them this is what you want to do. You can also give them the choice. Very often children may want a particular asset and be very happy to give up a particular asset.
Yeah.
Record that, get everyone to sign it, and then you have solved all of your problems.
Let's talk about what happens when you have a will. Do you necessarily have to have an executor? Because we asked people this and there was a little confusion about this as well. Because as I understand it, you have a few of these localities in India which used to be British principalities.
Presidency towns, yes.
And you have to have an executor, right?
So again, you don't have to have an executor. You can have a will and you can not name an executor. What happens then is that your heirs have to administer the estate.
Sure.
Instead of getting the executor applying for probate, if you have to, and I'll come to that in a minute, it is the heirs that go to court and say there is no executor. We are coming to you. Please give us letters of administration to administer this. So it's possible to have it, but it's definitely not recommended. You do want that executor to actually implement and execute the will. He or she is the most important person in your document.
Who should be that executor?
The executor is essentially someone who's trustworthy and reliable. That's point 1. 2 is ideally someone who's younger than the testator, because you want them to survive the testator. Yes. 3 is ideally someone who's in the vicinity, because they may have some running around to do all of that. And 4 is if you feel like there is going to be a challenge, then someone who can stand up to that challenge. Because executors, after the demise of the testator, can actually relinquish their role. So you don't want that. If they feel that that is not something they want to do, they can very much step back, and that defeats the point of having an executor. The other thing I think we should mention is that you can have a waterfall. You can either have joint executors or you can have a waterfall, saying I'm appointing these 2. If one of them can't act, then it'll be someone after them and after them. And so, Alex, sorry, coming back to your earlier question on presidency towns.
Yeah.
There are in Mumbai, Chennai, and Calcutta, the old 3 presidency towns. The Indian Succession Act says that, and this is slightly technical, so please bear with me, that if there's an executor or a legatee under the will, the executor is the person who executes, the legatee is the person who receives assets. If they want to establish their rights as executor or legatee, then the will needs to be probated. This is very often regarded as compulsory probate. It's not compulsory. The will is valid even without the probate. But if they want to establish their rights in court, then they need a probate. That is not the case anywhere else in the country.
Is it always a good idea to register your will?
It is very often a good idea to register a will. Especially if a challenge is expected, because it certifies to some extent the genuineness of the will. It also certifies the time of the signing. And if there is real estate involved, then there are a lot of local authorities who will want to see a registered will, although it is not compulsory. Legally, it's not compulsory to register a will, but it is especially for people who are aged and their wills may be challenged, a good idea to register a will.
Transfer of assets through the will, the physical asset, which is real estate.
Right.
Have you facilitated this taking place, and what is the process?
So I have not personally facilitated that because we stay away from getting into any position which could lead to conflict of interest as an advisor. So I stay out of that. But we do facilitate where we reach out to lawyers who help them in finding the right set of people because they have a set of, they have a set structure which takes care of that. And to add on to what Shaishavi was saying was that I believe executor can't be also a part of the will, right? That
cannot be
make a challenge.
Cannot be a legal heir.
They can actually, but what the law says is if you have it, then if they relinquish the role, then they lose the bequest. So what we do is we always write in the will that my executor, I am giving them a particular bequest or an asset, not in consideration for them acting as executor, but out of natural love and affection for them.
Understood. Okay. Just to close out this conversation, there is also this debate about whether or not you should transfer assets before your death. And interestingly, one of the conversations that I had on this very program is that there was a strong case that was made that if you have the ability, transfer the asset. If you're worried, for example, about real estate and being kicked out of your own home, then make a caveat saying that you have the right to occupy the property while you are alive.
Correct.
And there is also the creation of a trust that people talk about.
Yes.
Another complication is the HUF, to say that does that, for tax purposes, people do this, but can it create problems when it comes to transfer of assets? Those three aspects I want to talk about in no particular order.
Okay, maybe I'll start with the last one first, the HUF, because this is actually a case I'm actually facing right now. The issue with an HUF is that, yes, many people create it for tax reasons or they have existed historically, but there is no one law in India on HUFs. The law in India on HUFs comes from jurisprudence, from commentaries of jurists, as well as case law. And those are not always interpreted well. For instance, I'll leave some questions for the audience. Is a wife a co-partner in the HUF? Do people know answers to that? Daughter is a co-partner, but are her children co-partners? If there is a partition between the husband and children, does the wife get a share? If yes, and the answer is yes, then if the husband passes and there's a partition between the children, does the wife get a share? These are not easy answers, which is why it complicates. And I'm sure there are a lot of your listeners listening and saying, yes, I have the same questions. What are the answers? And the problem is that there is no one law that sets out the answers. Different courts may have taken different views on some of these things. So our advice to people is that if you don't need the HUF, partition it. Income tax does not recognize a partial partition. So preferably close it and distribute the assets if that's possible to do.
So it sounds okay when you're trying to deal with tax matters, but then down the line it can create a lot of problems.
It could very well create
problems. What about the trust? Do you have an opinion on creating a trust?
Not in particular order, but only when you have sufficient asset that could, let's say, support the kind of and maintaining of that trust would take, then only to set it up. Because if you're in low net worth kind of situation, probably maintaining that trust would be quite expensive a proposition, is what we always think of.
And stamp duty. If you move physical assets into a trust, there are stamp duty costs.
And transferring it beforehand. There are some states that allow you to transfer, for example, physical assets without having you pay. I think Uttar Pradesh is one of them where you can transfer real estate without having to pay that stamp duty. If that is available, can you do that? Can you, from a legal standpoint, transfer the asset beforehand?
You can, but I think there are lots of states that offer a dispensation for stamp duty, but it is usually for relatives or family members.
Yeah.
There are very few states, if any, that will offer it for a trust. And
I'm talking about transfer of assets before your death to your family members.
Oh yes, for sure. That is, again, there are some considerations. So I think it's not a yes and no answer. The first consideration is, of course, what is the stamp duty? Are you in a state that gives you that dispensation? Two is, do you have multiple assets? If this is your family home, are you comfortable gifting it onwards? If you have other assets, of course, then feel free to do that. As if your family home is concerned, and you are gifting it to a family member, then make a document like you said. There is a Senior Citizens Act in this country, and a senior citizen is anyone who's above 60 years old. When they are gifting this property to their family members, to their children, they can have a clause in the document saying, if you do not maintain me, then I can take back this property from you. So that is an important clause to have. There are different courts that have said that even if that clause doesn't exist, you can still take it back, but I would definitely recommend having it in writing. And if that person then doesn't maintain you, if the person you're passing the property doesn't maintain you, you can go to what is called a maintenance tribunal and have that cancelled and have your child evicted.
At what age do you think children should be brought into the fold and told about financial assets?
Probably when the kids are adult, it's a good time to start sharing all those information with them, because they are anyway would be able to take care of it in your absence.
Okay. All right. So I think we've covered quite a bit of ground. Thank you so much for taking the time. I think we've had a very important conversation, and hopefully we've encouraged people to start thinking about what they need to do, even if it's not the most comfortable thing to do. Thanks so much for listening in. This is NDTV Profit.